Brad is not here, but I want to say on behalf of both of us, we're really very grateful for the opportunity to be able to present this paper. I want to thank the organizers, especially Mike and Mike, for letting us be here, and thank Ingrid for providing a comment. You know, Brad and I have for some time been writing papers that I think would fall into the category of applied originalism, and this really is kind of our first foray into writing on originalism itself. So being new to the arena, I can say this is not just boilerplate, this is truly a work in progress. So your feedback is not only welcomed, but will be much appreciated. And already this paper has benefited from, and in some respects builds upon the insights of excellent work on originalism, by those of you who are here. So the paper really attempts to make two contributions. The first is to contribute to understandings of original methods originalism. What original methods actually were. I guess in this regard, to borrow a phrase from Adam, it's merely descriptive. We would not be the first to observe that identifying original rules, original methods of constitutional interpretation is a very complicated enterprise. Agreed. But, that said, if there is anything to original methods, originalism, then we've got to figure some of it out. And so Brad and I approached this paper, attempting to, roll up our sleeves and see, what rules, seem to be playing the most significant roles in the drafting, the debating, the defending, and of course, the interpreting of the Constitution. Beyond that, our second attempted contribution here is to contribute to understandings of how these methods so identified more may inform debates over how the Constitution should be interpreted. Certain scholars, some of you are here, have argued that original methods requires originalism, and in some ways we believe the case is even stronger than it's been made to date. So we begin with a question that others have begun with as well. What kind of a legal instrument was the Constitution? It was innovative, to be sure, and so there has been a search for what's the best analog for this innovative legal instrument? Was it most akin to a statute, to a treaty, to a compact, to a contract, to a state constitution? This question, to what form was the instrument most analogous? May be less important than what legal operation this instrument performed. As we went down this road and performed this research, it seemed to us hard to get around the fact that the Constitution was an instrument that partially transferred sovereign rights and powers from the states to a newly created federal government. In this paper, we recount the history of why that is, and some of it is, of course, very, very familiar. The states declared themselves to be, quote, free and independent states in the Declaration of Independence, entitled to all the rights as such under the law of nations, and the Treaty of Paris proceeded to recognize that independence. As free and independent states, the states entered into the Articles of Confederation, to our minds a treaty by which they ceded some, but certainly not all, of their sovereign rights and powers to the Confederation, and the Articles made that perfectly clear. Of course, the Articles failed of their intended purpose, and almost all, if not all, of the states violated them in material ways. And so under the law of nations, the states were then free to abandon the Articles because of the breach on all sides, and they did so. So at the Federal Convention, the delegates from the states hammered out a draft constitution, the essence of which was to transfer some but not all of the state's sovereign rights and powers to a newly created federal government through hard-fought compromises. At this convention, it seems to us everything was on the table, going separate ways, forging alliances with other nations, establishing two confederations. And so as the Constitution was drafted, and once it was drafted, and as it was debated, and once it was ratified, it was not lost on anyone that disputes would arise over the extent of the transfer of sovereign rights and powers that this instrument made to the federal government. Under the law of nations, general law, if you will, there were rules that govern the extent to which a legal instrument, whatever its form, ceded, divested, extinguished sovereign rights. And this isn't to say general law, the law of nations, was a closed system, and the common law was another system. The common law adopted the law of nations. And so there was much overlap in the rules that applied to any legal instrument. A first principle was that the intent of the lawmaker or the lawmakers controlled, but actual subjective intent being an elusive and manipulable concept, interpreters had to rely on, quote, outward signs of what that intent was when the instrument was made. In line with this enterprise, provisions expressed, general rule of interpretation, provisions expressed in clear and precise terms should receive their ordinary and customary meaning at the time of adoption. And that was important and relevant to writers on the law of nations at the time of adoption. And language did sometimes convey something that was determinable. And sub-rules assisted with this inquiry. Technical terms should receive their technical meaning. Figurative expressions should receive their figurative meaning. All that said, in addition to these kinds of general rules, there were particular rules that applied to alienations of sovereign rights. If after applying the conventional rules, it was not clear whether a legal instrument or a provision thereof ceded, divested, extinguished a sovereign right, then the instrument should be interpreted not to do so. Why? What was the reason for these rules? Well, a significant part of it seems to be that adjustments of sovereign rights and powers were momentous acts. They were not casual occurrences. And they were momentous acts, whether they occurred by agreement, whether they occurred by unilateral action, and misunderstandings about sovereign rights and which had been exceeded and which had been divested could lead to misunderstandings, to fraud, to conflict, or even to war. And these rules were designed to prevent fraud, to prevent misunderstanding, and to prevent conflict. So we argue that the Constitution, with these rules well established and known, was crafted and debated and adopted on the basis of them and largely interpreted in accordance with them. A central anti-federalist concern, perhaps the central anti-federalist concern with ratification, was that the newly created federal government would not abide by the terms of the partial transfer. In other words, that the United States would exercise sovereign rights and powers that it did not receive in the Constitution. The response to this concern by defenders of the Constitution was that, well, first of all, the Constitution is a partial transfer. It's not a complete transfer. There are rules that govern partial transfers, and the consequences of not following those rules are momentous. We can expect that they will be followed. Well, Hamilton said they apply by the very tenor, or he said the very tenor of the Constitution admitted them. So that's kind of point one, a descriptive point about certain rules that seem to have influenced the crafting, the debating, the ratification, and ultimately the interpretation of the instrument. Point two, so what? Why do these observations matter? In the paper, we suggest 3 implications. We only asked you to read one of them. The first 2 implications, I guess, are more sort of descriptive implications. Number 1, it's not the case on our reading of the relevant materials that legal interpretation of the Constitution was a late-breaking development with the Marshall Court. It seems to us that legal interpretation of the Constitution began right away, even though, and actually because, the Constitution was a form of fundamental law alienating and transferring sovereign rights and powers. Implication number 2, we're not talking about strict construction in the way that Jefferson and Tucker favored strict construction of the Constitution. I didn't have you read this, but one of our implications is that the Constitution under these rules did not require any general rule of strict construction. Third implication, the one that we did have you read, is that given arguments that have already been made about original methods, originalism, we believe there are even stronger arguments that the Constitution and the law of interpretation that existed at the time require originalism. It's not just, as Will and Steve Sachs have argued, that there was an original law of interpretation that has to continue to apply unless and until it's validly changed. And it's not just, as Mike and John have argued, that the law of interpretation was part of the language of the Constitution or should be regarded as part of the language's context. It's also, and as you can see, I'm not trying to forge divisions here, it's also that an instrument transferring sovereign rights was operative only in light of the rules of interpretation pursuant to which it was made. There was no thing in law as a transfer of sovereign rights that occurred by virtue of an open-ended or vague, maybe yes, maybe no, alienation of rights or powers. To enable the recipient of sovereign rights to change the rules of interpretation, if such a dynamic, even existed, an instrument would have to confer that power expressly. And nothing in the Constitution seems to do any such thing. To the contrary, the outward marks seem to point in the other direction.